Mr. Mosier, your position extends to a case in which the contractor does something that's an explicit violation of government policy. So just assume, which I know you contest, but just assume for a moment that a provision in the Fluor contract made it quite clear that Fluor was not to operate in the way that Fluor, in fact, did. What is the uniquely federal interest there?
So the uniquely federal interest, we would still define it as the federal government's exclusive authority in determining how to wage war. Where we would see the conflict, even within the situation in which there has been a finding of breach, is when state law is trying to impose additional or different sanctions than the military. So here they point to the finding and the determination where the Army has said that there was a violation of contract, but the Army determined that what was in the military's best interest was not to terminate the contract, but to continue to work with Fluor going forward. That conflict looks a lot like the conflict that the court found sufficient to find preemption in Arizona versus United States, where there was a different method of enforcement in Buckman, where the state was trying to impose additional liability for fraud to the FDA, and even in Garamendi. And what the court said in Garamendi is that if the federal government decides as a matter of foreign policy to use kid gloves in addressing an issue of foreign policy, and a state wants to address the same issue, but they want to do it through an iron fist, that is a conflict that warrants preemption because it's left to the executive branch to calibrate the appropriate remedy. And we think the same analysis applies here. It is, the military could have terminated the contract.
If that's the case, what you're